Can you hear me, guys?
Yes. Yes.
It was down, all right. We're waiting on the jail. Mr. Argila, can you, never mind. Text Mr. Fulton and ask him if there was any, substance, use, assessment done on, Mr. Hertzman?
I'll find out, Judge.
I think it's specific to order, unless this was a, yeah.
Sorry, we have some technical issues, Your Honor.
Okay. You're loud and clear now.
Is that Hersman?
Yes, Nathaniel Hertzman.
Is that him?
You're Nathaniel Hertzman?
Yes, sir.
All right, this case number 19 CR 165, State of Ohio versus Nathaniel Hertzman. This hearing is being conducted by Zoom. Mr. Hertzman is appearing from the jail. His attorney is Dennis Kirk. He's appearing from his office. Prosecutor Collins appearing on behalf of the state. Mr. Argila is the president of the probation department. Defendant had entered pleading guilty to the aggravated possession of methamphetamine and being given intervention with conviction. There was notice of violation of that file. We had a hearing. He admitted to the violations on the 19th, and the matter was set for disposition today. I did receive the updated report, although I don't see that there was an assessment done for residential treatment. There's an indication there's been some attempt for the defendant to contact Shawnee mental health, and then they tried to contact him, but unable to make contact with Leslie because he's incarcerated. All right, Mr. Kirk, you can find a both agree to conducting this hearing virtually rather than being in person in court.
Yes, Your Honor, due to the current COVID state, we would agree.
All right, Mr. Urban, that's okay with you?
Yes, sir.
Hey, now, Mr. Herman, since we're not in the courtroom, you're not sitting next to your attorney, please talk to him about anything, let me know. I can put the two of you in a breakout room where there's just be two of you talking, and no one else will be able to hear you, and no one else will, it won't be recorded, no one will see you or hear you, okay?
I understand, Your Honor.
All right, anything from the state regarding sentencing?
Your Honor, we would ask the court to place the defendant on community control, noting that this is his first felony conviction. It is a violation of intervention in lieu, and as such, community control is likely appropriate. Thank you.
All right, Mr. Kirk?
Thank you, Your Honor. We would also ask for community control. We understand that once the intervention in lieu is terminated, that is the next logical step. So we would ask for community control and whatever treatment the probation department has recommended.
All right, Mr. Herdman, anything you'd like to say?
No, sir.
One thing, my understanding from the CSI is that there is a warrant for Mr. Herdman out of Sedonia County from an indictment on May 28th. Illegal conveyance, surgery, felony, pickup anywhere in Ohio. Officer, do you know if you have a holder there on the end of Sedonia County? There's an outstanding warrant on it.
Give me just a second, Your Honor, and I'll check.
All right, thank you. All right. Mr. Archibald, did Mr. Fulton indicate whether or not there was any assessment done?
He hasn't gotten back to me yet, Your Honor.
I'm sorry?
He hasn't gotten back to me yet.
All right. Well, I normally order those in my standard order, but since this is an ILC, I just assume that you do it since we're terminating violation. But, I don't have any record. This does say that it should complete treatment, but it doesn't really give anything beyond that. So, all right. Well, Mr. Herdman, the court is going to put you on community control for a period of 3 years as a sentence. And you'll be required to comply with these conditions. First, you obey all laws of all jurisdictions, conduct yourself in all abiding manner at all times. Report when and as directed. Be truthful in all statements you make to the probation department. Keep them informed of your residence, place, and employment at all times. You can't change either without prior permission. You may not leave the state of Ohio at any time without prior permission. Enter upon the grounds of any correctional facility, or may communicate with or attempt to communicate with anyone in the inmate in the facility without prior permission. You may not purchase, possess, own, use, or have under your control any kind of arm, ammunition, dangerous orders, weapon of any other type. And because this is a drug conviction, the disability on firearms and ammunition, dangerous orders, that continues even after you complete the sentence. And if you do any of those things, you could be subject to being prosecuted under both federal and state law. Now, you're not permitted to purchase, possess, use, have under your control any kind of controlled substance, or use CBD oil, creatine, or any variant, or analogs of any controlled substance that's similar to those. And you're not permitted to have any device or instrument thing that can be used to prepare the administration unless you have a lawful prescription for both. You must provide that within 24 hours of receipt if you do have a prescription. You must submit to drug testing when and as directed. Possess, use, have under control any kind of alcoholic beverage normally present places of the soul being consumed and otherwise lawful. Not to associate with anyone who's a co-defendant in this case or any other person as a criminal record, member of the gang, or a criminal group, or any person who has in the past or could in the future. Influence you to commit a criminal offense or violate these conditions. That applies to any family members that fall within that definition unless you were living with them immediately before the commission of the offense. After the date of this order, you may not enter into a common law marriage type relationship with another person without written permission. You must report any, and shall report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law, not later than the next business day after that occurs. Then provide your supervising officer a financial information record so your ability to pay fees and costs will be reviewed. If you're referred for evaluation or assessment, which you will be, or any treatment, therapy, counseling, training, programming, you're submit to that. And if the programming is indicated, you're assessed to complete that. I know that's going to happen because you've got a drug problem and it should have already happened. And you didn't follow through on that before we got put to bed. So that's going to happen. You're paid court costs and payment arrangements. You have to successfully complete a 3 treatment plan for substance use disorder. I'm gonna guess it's gonna be residential, but, you know, if they say IOP, I mean, potential outpatient, that, you know, leave that up to the assessor. And you complete any aftercare. You report to probation immediately upon your release. And, Deputy, did you find out if there's a holder on him?
Yes, Your Honor, he does have a holder out of Sonoma County.
Okay. Well, he's going to be released today on this charge and then go to that. And once your dad's done there, Mr. Bergman, you're to report to probation.
Yes, sir.
On your release. Because, unless they put you, hopefully they'll put you in a treatment program if you end up getting convicted. If not, you know, we're going to do that. But if you get out of jail down there and you don't contact them, and you find out that you're out, you're going to have a warrant, they'll let you know, I'll issue a warrant for you, that'll be a violation. You need to be in touch with them as soon as you get the street.
Yes, sir.
What you need to be is in a treatment program. And again, I'm thinking it should be residential, since you didn't make it on,
I want residential.
but, you know, again, that's up to the treatment professionals. Now, by being placed on community control, you're deemed to have consented to a search without a warrant for person, residence, vehicles owned by you, or used by you, or any other property placed under your control where you're found at any time by any officer of the probation department. Won't be any fine, won't be any license suspension. You will be ordered to pay the court costs as a condition. It's also a subject order. If you don't make arrangements and start making payments, then the clerk will collect after your various meetings, including levying on bank accounts, wage earnings, or other assets that you may have. If that doesn't collect it, then the court authority to do community service, give you credit for each hour you work, and an hourly rate set with authority each hour you work, and reduce your judgment by that amount until paid in full. Now, in the event that it's alleged you have failed to comply, then a notice of that will be filed in writing with the court, served on you. You'll be held at that hearing. The outcome of that hearing is that you have failed to comply, and at that time, the court will revoke your community control and sentence you to 12 months in prison, fine you $2,500. If that happens, once you complete the prison term imposed by the court, the adult parole authority has the option, once you finish that sentence, to put you under post-release control supervision for up to 3 months, or 3 years. And if they do that, and they determine that you have failed to comply, they can return you to prison, they can serve an additional period of up to half of the prison term that was ordered to be served for one or more violations. But if you commit a felony, then in addition to whatever sentence the judge in the new case to impose, that judge is also authorized to sentence you for violating, committing that violation while under post-release control. In this case, to an additional period of 1 year, whatever time that on a 3 years of post-release control, whichever is greater. If that occurs, that will have to be served consecutively to the sentence in the new case. All right, so you're ordered discharged from custody in our case. However, there's the holders of the, they will be coming to get you, I assume. And again, if you get out on bond down there, or you go through the case and it's disposed and get released, you report to probation here, you know, immediately. I mean, by the end of business, the day following your release. You understand?
Yes, sir.
All right, thank you. All right, do you have any others, Mr. Kirk, that are in jail?
Yeah, in fact, I have Mr. Murphy.
All right, Murphy? Matthew Murphy?
All right, three
Yes.
three cases.
3 cases, okay.
On the record, Murphy.
All right, are you Matthew Murphy?
Yes, sir.
All right, there are 3 cases involving Mr. Murphy, 20 CR 207, 20 CR 267, and 21 CR 89. All state versus Matthew Murphy. The defendant is appearing from the Justice Center. This is a hearing being conducted by Zoom. His attorney is Dennis Kirk. Representing the state is prosecuting attorney Hopper. The defendant is charged in 207, receiving stolen property, and 267 with aggravated possession of methamphetamine, possession of drugs, 2 counts, and aggravated possession of drugs. And in 89, he's charged with failure to appear. All right, and I think this is upon a pretrial, at least on the earlier 2 cases. Actually, on all 3, I believe. All right, so is discovery complete?
It is from the state.
Mr. Kirk?
It is from us as well, filed our reciprocals this morning in the other two cases.
And there are no pending motions?
Not at this time. The state and I have continued to discuss the case, and they did make an adjustment to the plea offer, which I took out to him this morning. He would like some time to think about that. I explained to him the court's 2-week rule, and he wants me to come out and see him. And I'm going to be out of the office next week, but when I return, so that we can discuss possible resolution.
Well, the problem with that is, if you're out next week, I'm out the following week. And so.
I think our 2 weeks starts or ends on the 28th of September. I think our jury trial is October 12th.
Oh, I thought it was a September jury trial. No, you're right. Okay, well then we're good. All right.
Okay.
All right, good. All right. Anything further than council?
No.
All right, thank you. All right, who else is there?
Travis Carter.
Is that yours too, Mr. Kirk? Nope.
Ms. Barger.
Barger says Mr. Kirk, or Barger, your case? Yeah. All right. She's still there?
Who we get, Your Honor? I didn't hear
Travis Carter.
you.
All right, are you Travis Carter appearing from the jail?
Yes, Your Honor.
All right, this is case number 21CR077. State of Ohio versus Travis Ray Carter. This hearing is being conducted by Zoom virtually. He is appearing from the jail. His attorney is Sarah Barger. She's appearing by Zoom, and also representing the state is Commissioner Collins. Ms. Barger, you and your client both consenting to this matter being heard virtually rather than in person.
Yes, Your Honor.
You're all right with that, Mr. Carter? You're okay with that, Mr. Carter?
Yes, Your Honor.
Okay. Now, Mr. Carter, since we're not in the courtroom and where you'd be sitting next to your attorney, if you have any questions you want to ask her or anything you need to talk with her about at any time during the hearing, just let me know. And then I can put the two of you into what's called a breakout room where you and she can talk privately. No one else will be able to see or hear you, and it won't record your conversation, okay?
All right, thank you.
Now, Mr. Carter is charged with aggravated possession of methamphetamine, a 5th-degree felony. He is set for trial. Let's see here. He was arraigned. There were 2 cases.
Mr. King advised one had been dismissed.
Oh, okay, yeah, the other one had been dismissed. That's true. Alright. And so this one is set for trial September 23rd. Okay. And this as I said, is aggravated possession of that. All right, Mr. Carter, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to the charge. Now, this is a 3-page document that the prosecutor's office prepares, and on page 3 there are signature lines, and I'll hold this up to the camera and ask you if you can identify and recognize your signature there on that page right below the sentence that says, "I enter this plea voluntarily."
Yes, Your Honor, that's my signature.
Okay. And it indicates that you signed it today, is that earlier this morning?
Yes, sir.
And when you signed it, was Mr. Kirk with you to go over with you and explain it to you?
Ms. Barger.
Yes, my attorney was present with me.
Mr. Kirk, I mean, okay.
Ms. Barger.
Ms. Barger, Your Honor.
Oh, sorry, I'm trying to do things here at once. All right. Now, the agreement states on page 1, Mr. Carter, that you are going to withdraw your not guilty plea, plead guilty to aggravated possession of methamphetamine, a 5th-degree felony under 2925.11 Ohio Revised Code. It further states that you understand that the maximum penalty for that could be 12 months in prison. If a prison term is imposed, the minimum would be 6. Could be a fine of up to $2,500, and could also be a license suspension of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Now, are you facing any felony charges in any other jurisdiction at this time?
No, I'm not. I'm actually sentenced to a halfway house in Claremont County.
Okay, so you're on community control then on another charge out of Claremont County?
Yes, Your Honor, the same charge that's here.
All right, and what halfway house are you at?
Turtle Creek. They're wanting to send me to Turtle Creek.
Turtle Creek, okay.
Yes.
All right, do you have a bed date over there?
No, I'm just waiting a bed.
Okay. All right. Now, under the law, in the event at some point in time you should be sentenced to prison in both counties, in both cases, those sentences could be ordered to be served consecutively, meaning one after the other. You understand that?
Yes, Your Honor.
Okay. Now, under the law, if you are sentenced to prison to serve a prison term, once you complete the term set by the court, the adult parole authority in this case has the option, once you complete that term, puts you under post-release control for a period of up to 3 years. They don't have to do it, they can, but if they do, then you will be supervised in the terms they set by a parole officer. And if during that period of time they determine that you have failed to comply, they have the authority to return you to prison, make you serve a sanction for that, a violation of up to, in this case, 1/2 of whatever prison term is imposed for one or more violations, that would be the tag. However, if you committed a felony while you're under post-release control supervision, then in addition to whatever sentence the judge in this case imposed upon you, the judge could also sentence you in this case to an additional period of 1 year, whatever time is left on that period of post-release control for committing that new offense under PRC. And if that occurs, that would have to be served consecutively as sentence in the new case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you're, I'm sorry, not there yet. Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison committing control sanctions. And that means that instead of going to prison, you put under the supervision of a probation officer on a term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were not compliant, they would file a written notice of that to the court, serve a copy on you, and you would be entitled to have a hearing and be represented by an attorney at that hearing. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke the commitment control, sentence you to prison for 12 months, fine you to $2,500. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, we still need to hit this. The charge in this case reads that on or about October 27, 2020 in Hyman County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine. So that's the charge, 5th-degree felony, the penalties I've described. And you understand what it is you've been charged with, what the state says you did, when, where, and how they alleged that you did that?
Yes, I do, Your Honor.
Have you discussed the nature of the charge, the evidence of the case, the possible legal issues of the case, the possible defenses you try to raise in trial, and possible outcomes of the trial with your attorney?
Yes, I have.
And are you satisfied with her advice and confidence in this matter?
Yes, Your Honor, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I'm not.
Are you taking any prescription drugs?
I take Seroquel and Venlafaxine. That's just for my ADHD, so.
Alright, it's not interfering with your ability to understand what's going on or to communicate?
No, Your Honor.
Has any threat been made to get you to plead guilty today?
No, they have not.
Now, on page 2, there are a couple of lines that are printed in bold and underlined, and it says, the defendant shall enter a plea of guilty to the indictment, state defense joint recommending community control, and defendant be referred to drug court. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, they have not.
Now, under the law, the matter of sentencing is up to the judge, not to the parties. So even though there's a recommendation that you be given community control with the drug court, I'm not required to follow either of those recommendations. So if you plead guilty, I could decide that you should be sentenced to prison for 12 months, fine $2,500, and your license suspended for 5 years. Do you understand that?
Yes, I do, Your Honor.
All right. Now, you have certain constitutional rights from this understanding court and accept pleading guilty from you. First of all, you have a right to have an attorney, and Ms. Barber was appointed to represent you. That wasn't simply for the purpose of working the case out, but to provide any defense that might be available to you under the law that you wish her to provide. So, if you decide you don't want to plead guilty, she'll still represent you through the trial if that's what you want. Do you understand that?
Yes, I do.
Under the Constitution, you have the right to have a jury trial on this matter, in which 12 people will be selected from a group of citizens that reside in this county, summoned for jury duty under your trial date. After they are selected, the evidence to be presented, they will be instructed on the law. And if And then they would deliberate, and that jury would then have to decide by unanimous verdict, meaning all 12 have to agree on whether or not to say prove your guilt or prove beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to testify either way, which means give up the right to have a jury trial, in that case, you have to hold a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not to say prove your guilt or prove beyond reasonable doubt. You understand that?
Yes, I do, Your Honor.
Alright, under the Constitution, you have a right to confront witnesses against you and cross-examine for your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, I do, Your Honor.
Alright, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, like the same. So, if you have witnesses you're not certain going to put in voluntarily, you request court orders called subpoena, and force those witnesses to come to court to be able to testify for once to do, so they don't want to be here. It's the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, I do.
Right under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to get evidence in this matter at any time, including trial. So no one can ever make a testify. The prosecutor can't, the judge can't. You decide, and if you decide not to testify, the fact that you did not testify, not be used against you in any way by any person at any time in case, no one's even not to talk about it, except in one situation, that is if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, I do, Your Honor.
You know, under the Constitution, you presume innocent until proven guilty by the state and every essential element of the offense charge. That means that the burden of proof is on you to try to show you're not guilty, the burden is upon the state to prove that you are. In fact, at trial, you don't even have to put on any evidence. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charge by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
And now originally, you entered a plea not guilty, which denied the allegations, denied you committed any crime, and it exercised or revokes all the rights I just described. If you change your plea today from not guilty to guilty, that is the opposite of not guilty. The guilty plea admits allegations of the indictment that's their crime, that you committed that crime. And that plea waives gives up all the rights that I just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter which plea. With that exception, your plea of guilty waives gives up the right to have a jury or court trial. Waives gives up the front witness against you and cross-examine your attorney. Which gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It waives gives up for privilege against self-incrimination because you're the one saying you're guilty, that's what you can find you guilty. Waives gives up for presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also suggests you can be sentenced immediately by the court. And finally, waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, should I sentence you to maximum sentence under other limited circumstances, to be able to file, that would have to be filed in 30 days, and your sentencing entry would be filed. Do you understand all that?
Yes, I do, Your Honor.
And are you a U.S. citizen?
Yes, I am.
And do you have any license or certificate from any state agency for any kind of an occupation or profession that requires a state license?
No, I do not.
Okay. Now, do you have any questions about the charge and possible penalties?
No, Your Honor, no.
You understand it?
Yes, I do.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea of, or your constitutional rights, I should say?
No, Your
You
Honor.
understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, I do not.
You understand that?
Yes, sir.
Is there anything you need to speak to your attorney about before we go any further?
No, Your Honor.
That is, it's your decision to withdraw your not guilty plea, pleading guilty to the charge, pursuant to the terms of this written plea agreement that you just went.
Yes, sir, it is.
Then as to the charge, which alleges on or about October 27, 2020 in this county, he did knowingly obtain, possess, or use of Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11, Ohio Revised Code, fifth degree felony, carrying possible prison term between 6 to 12 months, fine of up to $2,500, with possible license suspension of 6 months to 5 years out of your plea.
I plead guilty.
All right, the court finds that on this day, open court, defendants advised of all his constitutional rights made in knowing self and voluntary waiver of the same pursuant to Criminal 11, please accept the court file. Defendants found guilty of the offense, a fifth-degree felony is charged. Court will refer the matter to the probation department for pre-sentence report and also to the drug court docket for evaluation. We'll set the sentencing date for October 6th at 9 a.m. Are you being held in our jail on our charge now?
Yes, Your Honor.
So were you released from Warren County?
They released me from Claremont County to come here and.
Or Claremont?
Yep, discharge, yes, Your Honor.
All right. But you don't know when they haven't given you any indication when the bed date's going to be available?
No, I was the only person waiting to go to Turtle Creek when I was there last night.
Okay. Well, in the event that Mr. Barber, you might see if you can touch base with them or talk to the patient, but in the event that that opens up for him, we can probably have him release you with there.
Your Honor, Ms. Sturgill is looking into that. Tanya Sturgill's looking into getting him a bed somewhere else other than Turtle Creek. She's working on coordinating with the Claremont County Probation Department.
Okay. Well, that would be the preference if it's going to be drug. So, okay. Thank you.
Judge, could you tell the jail supervisor to get those email and log sheets when those guys are being released out of there?
Okay.
So
All right. Who is this like?
this will be Likens, yes, sir.
Deputy, Mel just reminded me, if any of those people are released, would you make sure you get an email and a cell phone number for them if they have one of those sheets we have so we can communicate with them and set up Zoom hearings if that's what we'll do. So,
Absolutely.
all right, appreciate it. Most of the sentences will probably be correct, be in person, but we'll see.
On the record, Likens.
Case number 21CR125, State of Ohio versus James R. Likens. And are you James R. Likens appearing from the jail?
Yes, sir.
All right, Mr. Likens is represented by Patrick Hafner, and the state is represented by Prosecutor Collins. The hearing is being conducted remotely by Zoom. Ms. Hafner, doing your flag vote of agreeing to have this hearing by Zoom rather than in person.
Yes, Your Honor.
All right. This is a pre-trial, and the defendant is charged with one count of aggravated possession of a third-degree felony. And I think this is first pre-trial, and I think we have a trial date in October, if I'm not mistaken. Although I can't seem to find it at the moment. So discovery complete.
This is the state.
I haven't done my compliance yet, but I will get that done.
Okay. Well, you have until the final pre-trial. I see the final pre-trial is the 6th, and the trial date's October 25th. And do you anticipate any pre-trial motions?
Not this time, Your Honor, but I would reserve that to the final pretrial.
All right, well, you have to the final pre-trial then. And has there been a written plea offer provided?
There has been, I'll be out to see Mr. Likens tomorrow morning and pass it on to him then.
All right. All right, anything else that we need to discuss at this time?
No, Your Honor.
All right. Then our next hearing will be on the 6th of October. All right, thank you.
Thank you.
All right. Brian Clemens?
Yes.
Yeah.
No, he is at
Good afternoon, Judge.
Cincinnati. Should be there.
I think that's somebody here. Okay, they just signed off, so that's the last one to jail.
Okay, yeah.
Right.
We're done with the jail.
All right.
Byron.
Brian Clemens on the screen. It has Brian in the lower left-hand corner.
Yes, Your Honor.
All right. Case number 21CR134, State of Ohio versus Brian Clemens II. His attorney is Chelsea Penzika, and the state represented by the prosecuting attorney Andy Collins. This hearing is being conducted by Zoom, a pre-trial being conducted by Zoom. Mr. Clemens is charged with a co-defendant with a counts of aggravated trafficking, and counts of aggravated possession, and a forfeiture. This is a first pre-trial, final pre-trial set on October 6th, and trial date is October 25. Let's see. I see that the state provided bill of particulars and a compliance with discovery Monday. You received those, Ms. Benzika?
I have, Judge, and I've spoken with Mr. King, and I haven't talked to the other prosecutor yet, but we have received everything. I don't think anything's missing at all. Mr. Bliley and I just got out of trial, so we haven't gotten a chance to go through everything just yet and go over it with our clients, but we have received everything by way of discovery.
All right. All right, your discovery will be due by the time of pretrial. Do you anticipate any pretrial motions?
Not at this time, Judge.
All right, they're also due by the time of pretrial. And has been a written plea offer provided.
There has.
Okay, you ever find where that is pending?
Yes, Judge, and I believe that expires at the final pretrial as well.
Okay.
Yes.
All right, anything else to discuss at this time?
Not from the state, Your Honor.
Not from the,
Okay, then, final pretrial will be the 6th of October, that most likely will be by Zoom as well, Mr. Clemens, so make sure you stay in touch with the probation department. Thank you. All right, Caitlin Owens.
I'm here.
Judge Adam Wiley for Caitlin Owens.
All right, case number 21 CR 135, State of Ohio versus Caitlin R. Owens. And you are Caitlin Owens on the screen there.
Yes, Your Honor.
All right. This is a hearing being conducted by Zoom, and the defense attorney, Mr. Wiley.
Well, you got it, sir.
Okay, Mr. Wiley. And also the prosecutor, Collins, is appearing on behalf of the state. The defendant is charged along with Mr. Clemens with 2 counts of aggravated traffic methamphetamine, 2 counts of aggravated possession, and forfeiture. This is the first pretrial, final pretrial set on the 6th of October, and the trial date, I believe, is October 25. I see that the state did provide discovery. Did you get that, Mr. Butler?
We can have discoveries all made on the state side, Your Honor.
It looks like you also got a bill of ticket.
We got everything.
All right, do you, your discovery will be due by the final pretrial then? Do you anticipate any pretrial motions?
No, sir.
Okay, well, if you do have any, they're due by final pretrial as well. And
Yes, sir.
has been a written plea offer received,
There has been, sir.
and you're fine aware of it?
Yes, sir.
All right. All right, any other matters that need to be discussed at this point?
No, there's been open communication with us in the state. Everything's very good, Judge.
Okay. All right, thank you.
Thank you, sir.
All right.
We're done till 2 o'clock docket, sir.
One, two.
I know counsel was here for one case, but he had to go over and discuss the,
Costa, Mr. Crowley,
yes, sir.
things that he representing Costa.
Yes,
Okay.
he's supposed
So we
to,
have more Zoom hearings this afternoon or all?
3 o'clock, 1 at 3.
We have one at 3.
Okay. 1 at 3 is that? Right. Case number 21 CR 113, State of Ohio versus Joshua Cross. Present for the state, so prosecuting Attorney Collins, Assistant Prosecutor King, present for the defendant, Attorney Krause. And you are Joshua Massa?
Yes, sir.
All right, the defendant is charged in an 8-count indictment with 4 counts of aggravated vehicular assault and 4 counts of OPI under 451119. This matter is set for a pre-trial today. The record should reflect that this is a case that was indictment in a previous case, 1 CR 152, that was merged, all the proceedings that were merged with this. Because the files were small. Okay, now, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3, a lesser offense of attempted aggravated vehicular assault. And this is a 3-page form that the prosecutor's office prepares from the form they have on their computer, and then they put in the information that's relevant to your case. On page 3, there are signature lines, and there's one paragraph at the top of page 3, and then right below that, there's a sentence that says, I entered this plea voluntarily. And immediately below that, there's a line under which the printed signature defendant, and there's a signature that appears to be Joshua Awesome. And is that your signature I'm looking at?
Yes, sir.
And did you just sign this here this afternoon?
Yes, sir.
All right, did you go over this with Mr. Krause before you signed it?
Yes, sir.
And did he answer all the questions, explain everything to you?
Yes, sir.
To you satisfactorily? Right? Do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
And this is something you and your attorney have been talking about before today?
Yes, sir.
So you don't feel surprised about what's happening here exactly? When you came here today, this is what's expected to happen?
Yes, sir.
Alright. And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
I got the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3. Currently, those are aggravated vehicular assault under 290308A1A, which are third-degree felonies. The agreement says you're going to plead guilty to attempted aggravated vehicular assault under 2923.02 as well as that charge. And what that means is that under the law, an attempt is a lesser offense to a crime in most cases. And so by amending this to be attempted as opposed to the actual offense, it basically says that you engage in conduct which is successful would result in the offense. And that reduces that crime by 1 degree. And so therefore, as I said right now, those 2 charges are third-degree felonies, which would be 1 to 5 years. And by the amendment, or the reduction, I should say, to the lesser offense of attempted aggravated vehicular assault, 4th-degree felonies carry a maximum prison term between 6 and 18 months and a fine $5,000. And there's also a license suspension and is that actually what that is?
It's on the form.
It's not on the plea form.
Judge, on the front where it says possible penalties.
Oh, I'm sorry, okay, yeah, I was looking at the agreement, okay, I'm sorry. 2 to 10 years, all right, that's the max, I forgot what class that is, but then that's the suspension, 2 to 10 years. And is that mandatory? Yeah, I thought it was, so that would have to be imposed. So the other penalties are possible, they're not mandatory, but that one is mandatory. You understand that?
Yes, sir.
Okay. Now, under the law, if you're convicted of both of these offenses and sentenced to prison, sentences will be over served consecutively, one after the other. That means the potential maximum penalty for these 2 offenses are 36 months in prison, fine $10,000, and a license suspension, 2 years on each charge. You understand that?
Yes, sir.
Other than these 2 charges, Mr. Costa, will you face any felony charges anywhere else?
There you go.
Are you currently on probation, community control, parole, post-release control, or a county in any jurisdiction?
Just
Right
Highland
now. All right.
County. Just Highland County.
Yeah, that's just pre-trial supervision. Okay. Now, under the law, if you are convicted and if you are sentenced to prison, then once you complete the term imposed by the court, it is possible the adult parole authority might choose what's called post-release control supervision for a period of up to 3 years. They don't have to, it's optional, but they make that decision, not the court. And if they do, you'll be supervised under the terms they set for a period of up to 3 years by a parole officer. And during that period of time, they determine that you have failed to comply, and they could return you to prison even though you served the entire term ordered by the court for an additional period of up to 9 months for one violation, but there is a cap or a limit of half of whatever prison term is imposed on all violations. But if you commit a felony, then in addition to whatever sentence the judge will do for imposed on you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year for every time done on the period of post-release control, whichever is greater. That occurs, that has to be served consecutively sentence in the case. You understand that?
Yes, sir.
All right. Now, not required by law to sentence you to prison, you can impose community control, which is probation. And what that means is instead of going to prison, you would be supervised on a term set by the court by a probation department, the county probation department, for up to 5 years. If during that period of time that you were under supervision, the probation department felt that you were non-compliant, they would have to file a written notice that with the court, serve a copy on you, then the court would have a hearing, and you would be probably represented by counsel. And if the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to 36 months, fine you $10,000. You understand that?
Yes, sir.
All right, now the amended charge, I'm actually going to say amended this reduced, and I'll read what the charges are, and I'll play the intent. I believe they're the same. But different victims, is that correct?
Yes, Your Honor.
Yeah, okay. So, the allegation reads in count 1. On or about February 29, 2020, in this county, you did while operating or participating in the operation of motor vehicle, motorcycle, snowmobile, locomotive, watercraft, or aircraft, with a Toyota, cause serious physical harm to Amelia Treadway as approximately result of committing violation of Division A of Section 4511.19 of the Iron Class Code, or the substantially equivalent municipal offense, violation of Section 2903.08A1A. And 4511.19 is the OPI section. I'm sure your attorneys explain that to you, but I have to make sure I explain it as well on the record. Now, the amendment or the reduction into attempt would mean that it would read at the beginning, after the date in the county, and say that you engaged in conduct, either knowingly or purposely, which if successful, would have resulted or constituted the offense. And then the rest of the offense follows. And that's what makes it a fourth-degree felony. And then count 3 is the same, except a different person. Instead of Ms. Treadway, it's Anna Charwood. I think, I don't know if that's right, but Charwood glad was passed. You understand that?
Yes, sir.
Now, Mr. Constant, do you understand what it is you're accused of in each of those 2 counts, what the state said you did, when or how they alleged that you did it?
Yes, sir.
You discussed the nature of these charges, the evidence in the case, possible legal issues in the case, possible defenses you try to raise at trial, possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Now, on page 2, and a little over halfway down the page are 2 plus lines printed in bold and underlined, and then added to that has been some ink written to make it over 3 lines. So let me read that to you as follows. Finish, shall enter plead guilty to count 1 and count 3 as amended. State will dismiss count 2 and count 4. State defense will argue sentence. Defense shall make full restitution at a child away in the amount of $5,183.62. Is that your understanding of the agreement?
Yes, Your Honor.
Now, actually, would the count 5 grade also be dismissed?
All counts would be dismissed.
It just says counts 2 and 4.
Yeah,
Okay, I think this must have been under the old plea agreement.
right.
Under the old case, all right. So, if this is right, Mr. Krause, I have 2 and count 4 and 8.
Yes, Your Honor.
Thank you. All right, so I'll underline that in there, putting my initials next to it for the record, so somebody tries to read it, and be able to find it out for the record. All right. Now, other than that, has anyone promised you anything to get you plea guilty here today?
No, Your Honor.
And has the state consulted with the 2 victims about this disposition?
Yes, Your Honor,
They're aware of this proceeding?
Yes,
They're not present.
that's correct.
Okay. And, now, so, no one has promised you anything other than that gets you plea guilty?
No, Your Honor.
You're not been promised that if you plead guilty, you're going to get a certain sentence?
No, Your Honor.
Right. Do you understand that there's a possibility of a prison term if you plead guilty?
Yes, Your Honor.
And as far as restitution, Mr. Krause, you're stipulating to that, not requiring it.
Yes, Your Honor. The state provided us proof of documentation of that, and we stipulated the amount.
All right, thank you. Now, Mr. Costa, do you hold any license or certificate from any state agency or any occupation profession require state licensing or certification?
No, Your Honor.
All right, now you have certain rights you understand before I accept your plea of guilty, but before I get to those, I'll inform you that you're aware you have right to have counsel to employ Mr. Costa or Mr. Krause to represent you. Now, in the event that you could not afford to continue to pay him for his representation, then under the law, the court would appoint an attorney for you at no cost because you're willing to pay. And so the reason I say that is just to make sure, as to this question, that is, you're not entering into an agreement to plead guilty because you're worried you're not going to be able to pay Mr. Krause and defend you in the trial. That's not a concern, is it?
No.
Okay, that's what I'm trying to get to. All right, thank you. Now, under the law of the Constitution, you have a right to jury trial on these charges, which means that a jury of 12 persons would be selected from a group of citizens who live in this county, summoned for jury to be on your trial day. After the 12 are selected, the evidence will be presented, they then be instructed on the law, and then they will decide on a unanimous verdict, meaning all 12 have to agree on whether the state proved the charge or charges against you. Now, if you didn't want to have jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning the judge would be going to hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a doubt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you in open court and to have your attorney cross-examine. So what that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court would issue a court order called a subpoena. And of course, those persons that are named in the subpoena to come to court to testify if you want them to, though they don't want to be here, which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination in this case. And what that means is that you are not required and cannot be compelled or to testify against yourself at any time in these proceedings. No one can ever make you testify. The prosecutor cannot make you testify. The judge can't make you testify. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to comment about it except in one situation, which is if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof is on you to prove that you're not guilty of these charges. The burden is upon the state to prove that you are. In fact, at trial, you don't have to present any evidence in your defense. You may, but you're not required to. Whether you do or not, the state of Ohio will have the burden of proving your guilt of every essential element of each of the offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes,
Right now, originally you entered a plea of not guilty to this charge. Not guilty plea denied the allegations, denied that you committed a crime, and then exercised or invoked all the rights and efforts described. Now, if you change your plea from not guilty to guilty to the reduced charges in counts 1 and 3 of 10, that is the opposite of not guilty. That plea admits the allegations in the reduced charge, admits that they're a crime, and that you committed those crimes. That plea gives up all the rights I just described. So you set your right to have an attorney. Because you always have a right to have an attorney, no matter what you plead. Without exception, your plea of guilty gives up the right to a jury or a court trial. It gives up the right to confront witness against you in open court and your attorney cross-examine. Gives up your right to use the power of the court to compel or force witnesses in court to testify or accused, like the state. Gives up your privilege to self-incrimination because you're saying you're guilty, and that's what you find. And gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. I thought that was the right thing to do today. And finally, gives up all any alleged right to appeal, any alleged violation of your rights you feel could have occurred up until this point in the case. Now, if I should sentence you the maximum sentence or another certain limited circumstances, you can file an appeal. That would have to be filed in 30 days for your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
What was that?
Are you a U.S. citizen?
Yes, sir.
And again, you're entering into this plea agreement voluntarily?
Yes, sir.
Now, do you have any questions about the charge as reduced, attempted, aggravated behavioral assault?
No, Your Honor.
You understand?
Yes.
Any questions about the, you
No, Your Honor.
understand?
Yes, sir.
Do you have any questions about the constitutional rights of the plaintiff?
No, Your Honor.
You understand?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that here today? You understand? Is there anything you'd like to speak to Mr. Krause about before we go any further?
No, Your Honor.
It is your decision to withdraw your not guilty plea and plead guilty to the reduced charges in counts 1 and 3 of attempt to commit aggravated behavioral assault, as we just gone over in this plea agreement.
Yes, sir.
Right, then as to the charge in count 1, which as reduced would mean that we agreed on or about February 29, 2020, Miami County, Ohio, you did engage in conduct which is successful, purposely and or criminally engaged in conduct which is successful would have constituted or resulted in the offense alleged in count 1 of while operating or participating in an operation of a vehicle, motorcycle, snowmobile, locomotive, watercraft, or aircraft, with Toyota, cause serious physical harm to Amelia Treadway as a proximate result of committing a violation of Division A of Section 4511.19 of the Revised Code, or a substantially equivalent municipal ordinance violation of Section 23.02A, I believe, and 2903.08A1, a fourth-degree felony of attempted aggravated behavioral assault, bearing possible prison term between 6 and 18 months and a fine of $2,500 and mandatory license suspension of 2 years and 10 years. How do you plead?
Guilty, Your Honor.
Then as count 3, which reads the same, except instead of Amelia Treadway, the person injured would be Etta Charleboy, CHRLESBOIS. But that otherwise it's the same offense, the same penalties. How do you plead?
Guilty, Your Honor.
Okay, you can see. Right, the court finds on this date open court, defendants advise all his constitutional rights made knowing, intelligent, voluntary Ready for the same pursuant to Rule 11. Please accept the order filed. Defendant is not guilty of the reduced charges in counts 1 and 3 of attempt to commit aggravated vehicular assault. Counts 2 and 4 through 8 are dismissed. The court orders a pre-sentence investigation. Also include a assessment for any substance use issues or mental health assessment, and mental health as determined by the probation department. While we continue, sentencing date set for October 6th. Mr. Krause, will you be there that day?
If I may check, Your Honor.
Yes, okay.
Your Honor, I have a trial in Adams County that week,
Okay.
but the next week, any day but the 12th is available. Actually, the 11th, 13th, 14th.
Okay. You say the 11th is Monday and then the next left, that is a Wednesday.
The Monday, Wednesday, Thursday.
Yeah, so the have to be the 12th, the 13th, the 14th.
The 13th, Your Honor.
Alright, that's a Wednesday afternoon, for us on Tuesday, but I'd say 3 o'clock. Is that better?
Yes, sir.
Alright. I don't think, passenger trials do, we should have time to work it in at that time. Alright, so Mr. Costa, you need to go down to the office, or get right there and see him, about you need to meet with the PSI officer, which is Mr. Fulton, for, he'll prepare the pre-sentence report, and you can give him information so you can, prepare the report. So you'll get an assignment notice from the mail here before you leave, and then as soon as you're ready. Anything further, counsel?
No, Your Honor.
Alright, thank you. Alright, let's see. Gentleman in the orange t-shirt, what's your name?
Derek Rarica?
I'm sorry?
Derek Rarica?
Alright, is your turn this with?
Yes.
Know where she's at? Take care of all her name, like that.
Right outside.
Have a seat there, Mr. Farragut.
I'm sorry.
Rarica, how do you have Rarica?
Rarica?
Rarica, okay, Rarica. Have a seat up there. Get your turn in here. Get that thing from the DRC on the,
I got that last week, Judge.
okay, yeah, I haven't had a chance to look at that. That's,
I think what it is that, and we didn't even think about it when we did it, but the crimes that he committed are before Reagan Coates took effect.
right.
So I don't think we need to do anything. Like, they just said, Reagan Coates doesn't apply. Okay.
Okay. I didn't have a chance to do it like that. I think they go here. All right, case number 21, CR 111, State of Ohio versus Derek. President of the state, prosecuting attorney Collins, assistant prosecutor King, present on behalf of the defendant is attorney Daniel Witt, and you are Derek Burr. Yes, sir. All right, Mr. Burr is charged with aggravated possession of methamphetamine, 5th-degree felony. This is a final pretrial and first pretrial, final pretrial set for 9/22, and trial jury set for 10/12. Now, I've been presented with a motion for intervention, lieu of conviction, and with the clerk said we questions have been completed.
They have, Judge.
Ms. Lip just advised us that her client's previously been convicted of a felony, which doesn't show up on a CCH, or we would not have offered intervention in lieu. But I was thinking that the law changed to allow that. He was convicted, I think, 21 years ago, she said, in California.
Well, let's go ahead and proceed with the motion for investigate law before back on that. It's been 21 years ago. He's eligible, depending on what the report back, certainly considered. But assuming it's not disabling, provision. And
So, well,
I haven't looked at the changes on that.
I thought that one of the changes was that even if he was previously been convicted of a felony, he could still do it.
I think you're right on that, but again, I haven't looked at it recently. That was just in, is that hospital one thing?
I don't think so.
The one before that?
One before that.
Yeah, they made some changes. The one where they did the changes on the ceiling and the
Yes.
funding and all that, yeah. All right, so Mr. Rarica, what is proposed here? And again, I appreciate your honesty and telling your attorney for, bringing that up, because that didn't show up on CCH. It may have one in the probation grant, because they have access to different databases before. But in any event, under the law, there is a provision that if drug substance use disorder is a cause or mental health is a cause of criminal offense, if you plead guilty, rather than find you guilty, the court can give you an opportunity to be in a program to treat those issues, and if successful, the case gets dismissed, even though you plead guilty. So that's what this is about. So it requires that they answer certain questions. And I know two of these are marked out because you have to have an intervention plan. If you don't have it, you have to go find out if you're eligible. And then secondly, you haven't been assessed yet by a provider, at least.
I'm in FRS.
Pardon me?
I'm in FRS.
Okay, well, that's good. But I mean, you haven't been assessed for court purposes. Okay. So, that means you need to, as all these other answers are correct. Okay. Well, then the court will order that that would be referred to probation department for a pre-sentence report, or a pre-hearing report, I should say. And then you'll also have to provide a piece of information to the probation department so they can get the information from FRS, provide, see what the diagnosis was, make sure it didn't match what's required by law, and that you're in an appropriate plan. And what we'll do is we'll set this for hearing. Let's see. Thankfully, did I say we have an October trial date? Yeah, October 12th. So let's see if we can set this for hearing, say, we'll have to vacate the trial date. Because we're going to have to have about 30 days and then we decided at the time. So we'll go ahead and set this for a hearing on October 21st at 1 o'clock. And so you need to see this Argina, and you'll need to make notes how you get in touch with Mr. Bolton and ask him to do your report and then try to get information from FRS, make sure that you're aligned with your program there. So just need to do that, and then you should be.
You said Mr. Arizona? Mr.
Right
Arizona?
here, offer. Yeah, he won't write the report, he's supervising right now, he'll tell you who to call and where to do it, so. Alright, so you won't have to be here on the trial date, but, maybe the sign doesn't fail for the 21st. So, just make ready to see Mr. Archie with the probation department, that's right. Okay, thank you. What you have is, Rick.
Charles Miller.
Charles Miller?
And he is not here.
Oh, okay, wait a minute, let me get one record.
I was just looking at the time, he's a 2:15 hearing. So. On the record, Miller.
Case number 21 CR 120, State of Ohio versus Charles E. Miller Jr., present for the state, prosecuting attorney Collins, assistant prosecutor King. Present for the defendants, Attorney Danielle Witt. Defendant is not present. Matter was set, I think, at 2 o'clock, it's now 2:29 or so, 2:22 actually, according to the computer. Ms. Witt, do you have any information about Mr. Billy's whereabouts?
Yes, Your Honor. My office received a fax this morning, where it looks like he was tested positive for COVID. Would you like a copy of this?
No, if you're reading that to me, I'll accept your, I don't want to put that stuff in the record, so. I mean, it's in the record, I mean, personal information, so he is in quarantine, or is he
Yes.
hospitalized?
Yes, as far as I know. As far as I know, it's just quarantine.
Okay, all right. Well, and the court will continue due to the availability of the defendant.
And there is one other matter, Your Honor, I need to address. I learned before I came over here that I represented his children as guardian ad litem in legal custody case that was completed in June of 2020. I was the guardian ad litem in legal custody, legal counsel for his kids.
All right. Well, I think that there's, I mean, there's not a conflict now, I don't think it's not actual. Does he have custody, or what's the situation with children?
No, legal custody was granted to grandparents.
Okay, so that is over.
Yes.
Well, that's something, I guess, I don't think it's an actual conflict unless he's uncomfortable with it. So maybe you can correspond with him, not first, obviously, and see what his feelings are. If he feels that he'd like to have another attorney, that would be fine. Yeah, then I would go ahead and have you withdraw with somebody else.
Okay, I'll discuss that with him.
Okay. And I want to set this for hearing today's the first, I think our next one is September 22nd. And we'll do that by Zoom. And hopefully he doesn't have it all recovered, with any extenuating circumstances like that. All right, is that it?
Thank you. I have, yeah, all for him.
All right. Okay, Donna Hughes.
Hey, Coach.
Okay. All right, case number 21CR030, State of Ohio versus Donna E. Hughes. President for the State, Prosecuting Attorney Collins, Assistant Prosecutor King. President for the Defendant, Attorney Sarah Barber. Are you Donna E. Hughes?
Yes, Your Honor.
This Hughes is charged with grand theft of motor vehicle by deception, a 4th-degree felony. This is the final pre-trial. Trial is set for September 23rd. I have been presented with a plea of guilty form, Ms. Hughes, which indicates you're going to withdraw your not guilty plea guilty to the charge. And this is a 3-page form the prosecutor's office prepares and puts any information about your case. Page 3, there are signature lines, and I'm near the top, at the top of the page, there's the ending of the paragraph, and then a sentence that says, I enter this plea voluntarily. And immediately below that, there's a signature defendant, what appears to me to be Donna Hughes. And is that your signature I'm looking at?
Yes, Your Honor.
And when did you sign this document?
Today.
All right, when you signed it, did you understand it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing?
Yes, Your Honor.
And is this something that you would, considered might happen before you got here today?
Yes,
You can tell, talking with Ms. Carter about it.
yes, Your Honor.
And have you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And are you entering into this agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, the agreement states that you're going to withdraw your not guilty plea, plead guilty to the charge of grand theft of motor vehicle by deception. Under section 2913.02A3 of fourth degree felony. Further states that you understand that the maximum prison term for that could be 18 months, the minimum would be 6. If a prison term is imposed, it could be a fine of $5,000. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else?
I don't think so.
Okay, well, I'm hoping no.
Yes, she is, Your Honor.
Okay, where?
Clinton County.
Oh, okay. Well, if you are convicted of felonies in both counties and sentenced to prison on both charges, they could be served, the sentences would be ordered to be served consecutively, meaning one after the other. So you get 2 sentences instead of 1. Do you understand that?
Yes.
Okay. Under the law, well, let me back up. Are you on probation now, or community control, or parole, or post-release control?
I'm on probation, I see Mr. Airy.
Okay, well, that's how this case, that's pre-trial. I mean, for a case in which you've been found guilty.
Oh, no.
Felony. Okay. Now, under the law, if you are convicted and sentenced to prison, once you complete the prison term imposed by the court, the adult parole authority has the right, if they choose to use it, it's optional, to put you under what's called post-release control for a period of up to 3 years under the terms they set. And if they find or determine that you have failed to comply with those terms, then they can return you to prison, even though you serve the entire term set by the court, for an additional period of up to 9 months for 1 or more violations, although there's a cap of half or whatever prison term could be imposed for all violations. So in that case, that would be the maximum, because the maximum penalty is 18 months and half that's time. But if you commit a felony while you're under post-release control, then in addition, whatever sentence would be imposed by the judge in the new case, the judge can sentence you, in this case, just to an additional period of 1 year, or whatever time's left in that period of post-release control, for committing the offense while under post-release control supervision. If that occurred, that would have to be served consecutively, meaning after the other. Do you understand that?
Yes, Your Honor.
Right? Now, I'm not required by law to sentence you to prison for this offense. I can impose community control or probation. And so instead of going to prison, you can be put under supervision of a probation officer as a term set by the court. And if during that period of time that you're under supervision, the probation department felt you were not compliant, they would file a written notice of that with the court and serve a copy on you. And then you would have a hearing and be entitled to have an attorney at that hearing to represent you. And if the outcome of the hearing was that you failed to comply, then at that time the court would revoke the community control and then sentence you to prison for 18 months and fine you $5,000. Do you understand that?
Yes, Your Honor.
Right now, Ms. Hughes, the charge alleges that on or about December 8, 2020 in this county, you did with purpose to deprive Westview Motors, the owner of the property, not only obtain or exert control over the property, to win a 2003 GMC Yukon, which property being a motor vehicle is defined in ORC 4501.01 by deception. Violation section 2913.02A3 of the Higher Revised Code. So that is the charge of grand theft of motor vehicle by deception, 4th degree felony. Now, do you understand what it is you're charged with, what the state said you did, when, where, and how they allege you did it?
Yes, Your Honor.
You discussed the charge with your attorney, the possible defense you try to raise at trial, the possible legal issues, the evidence of the defense, and possible outcomes of the trial with your attorney, with her.
Yes, Your Honor.
And are you satisfied with her advice and confidence?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
That is my prescription.
And what prescriptions are you on?
I'm on Suboxone and Readerel.
All right, I know what that is. Either of those medications interfere with your ability to understand what's going on and to tell you what's going on with you.
No, sir.
All right. Now, have any threats been made against you to plead guilty here today?
No, Your Honor.
On page 2, there are 2.5 lines printed in bold and underlined and read as follows. Defendant shall enter plead guilty to the indictment. State defense jointly recommend community control. Defendant agrees to make restitution to Westview Motors the amount of $2,965. Is that your understanding of the agreement?
Yes, Your Honor.
Anyone promised you anything else other than that to get you to plead guilty here today?
No, sir.
Under the law, Ms. Hughes, the matter of sentence is up to the judge, not to the parties. So even though there's an agreement that you should get it under control, once I've heard all the information, I could decide that that's not the appropriate sentence and instead give you a prison term. Do you understand that?
Yes.
Okay. And there's an agreement on the amount of restitution. There's no dispute on that, Mr. Carter?
No.
Okay. All right, now, Ms. Hughes, do you hold any license or certificate from any state board or commission for any occupation or profession?
I'm an SDNA.
Okay. Well, under the law, we'll have to send, the clerk will have to send a copy of the conviction to the, I guess that's the medical board, or whatever board it is that issues those, so that they're aware of the conviction, because conviction of a felony might be grounds for some sort of discipline, suspension, or revocation. Not that the court wants that, but that's what we're required to do. So that could be a consequence of the conviction. You understand that?
Yes, sir.
Okay. Now, under the Constitution, you have certain rights you need to understand before you can accept a guilty plea. First, you do have right to counsel. Ms. Carter was appointed to represent you by the court. Now, her appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you wish to provide. So, if you decide that you do not want to plead guilty, you will still be represented by counsel, and she'll defend you through the trial if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution as used, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial day. Once they are selected, there'll be 12. The evidence will be presented, and then they will be instructed on the law by the judge. Then that jury of 12, after agreeing on a unanimous verdict, meaning they were all after agreeing on 12, on whether the state proved your guilt. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the writing, which means to give up the right to have a jury trial. In that case, you would have to hold a court trial, which means that instead of a jury hearing the evidence, a judge would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond reason for that. You understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. That means that the witnesses have to come in court, testify in front of you and your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence which helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court and testify to you, just like the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a court order called subpoena. That forces those witnesses to come to court and be able to testify if they want to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or testify in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it, except one situation, which is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence. That you are presumed innocent of this charge, so proven guilty by the state of Ohio of every essential element of the defense charge. So, what that means is that the burden of proof is on you to prove you're not guilty. The burden is on the state to prove that you are. And in fact, at trial, you don't have to know any evidence at all. You may, but it's not required to. Whether you do or not, burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the defense charge and prove beyond a reasonable doubt, which is the highest burden of proof that is done under the law. You understand that?
Yes, sir.
All right, now, originally you entered the guilty plea to deny the allegations of the indictment and not committed any crime. And they exercise or revoke all rights that are described for you here this afternoon. Now, if you change your plea, not guilty, guilty, that is a complete opposite of not guilty. guilty plea will admit the allegations in the indictment and declare a crime that you committed that crime. And that plea will waive and give up all the rights you just described except your right to an attorney. You always have a right to have an attorney no matter what you plead, with that exception. Plead guilty waives gives up the right to a jury or court trial, waives gives up the right to confront witnesses and cross-examine for your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what she finds you guilty. And waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. Subjection being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you think you could have had up to this point in the case. Now, if I sentence you to the maximum sentence under certain circumstances, you file an appeal, it would have to be filed within 30 days of your sentence entry being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And you're entering into this plea voluntarily?
Yes, sir.
And you have any questions at all about the charge and possible penalty?
No, sir.
Do you understand?
Yes, sir.
Any questions about the plea?
No, sir.
You understand?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Anything you need to speak with your attorney about before we go any further?
No, sir.
All right, then is it your decision to withdraw your not guilty plea, plead guilty to the charge in the indictment, or so return to the plea agreement which just gone over?
Yes, sir.
All right, then as to the charge which alleges on or about December 8, 2020, in Highland County, Ohio, you did with purpose to deprive Westview Motors, the owner of property, knowing and obtain and exert control over said property, to win a 2003 GMC Yukon, property being a motor vehicle as defined in ORC section 4501.01 by deception, violation of section 2913.02A3, Higher Revised Code, the charge of grand theft of a motor vehicle by deception, 4th degree felony, very possible prison term between 6 and 18 months and fine $5,000. How do you plead?
50, sir.
Thank you, proceed. All right, the court finds by this date open court defendants applies all the constitutional rights made no intelligent voluntary waiver of the same pursuant to Rule 11. Please accept the order filed. Defendants found guilty of the charge. As set forth in count 1. The matters referred to the probation department for pre-sentence investigation, including assessment for substance use disorder treatment and/or mental health. Sentencing will be set for October 6 at 9 a.m. and bond will be continued. Will not need to be here on the 23rd of September now. Your trial date's off. Just around here, get a sign notice from bail and see Mr. Archie or their probation department so they can set up your appointment to see the pre-sentence officer. Okay?
Thank you, sir.
Thank you. Who else do you have, Barbara?
Mike Harrison.
Okay, Michael Harrison.
May I approach? Yeah. It's probably a big
You may. Case number 21 CR 116, Dale Ohio versus Michael Harrison. Present for the states, prosecuting attorney Collins, prosecutor King. Present for the defendants, attorney Sarah Barber. And are you Michael C. Harrison?
Yes, sir.
All right, Mr. Harrison is charged with one count of aggravated possession of methamphetamine, a 5th degree felony. This is pre-trial. Here. First pre-trial, pre-trial set for the 22nd, and trial set for October 14th. Now, I've been presented with a stipulated questions for intervention with conviction. See that, have you filed a motion yet, Ms. Carter?
No, Your Honor, I apologize, the motion has not been filed. I have filed by the end of the day of the board.
All right, that's great. So, what this is, Mr. Harrison, is a program that provides that someone who is that pleads guilty to a charge 17 found guilty, can be given the opportunity to go into a treatment program, and if they completely successfully comply with certain conditions, then their charge is dismissed, even though they're not guilty, they don't have to felony record, so that's a big advantage to you. It's a good opportunity for you. But it does require you to be in a treatment program. You see there, you haven't seen another chance, it looks like. There's that program, so that is a qualified program. But she'll file her motion, and these stipulated questions are the answers, all the answers on here, correct? Except those that are marked out.
Yes, sir.
Okay, all right. The court then will order that there be an investigation prepared and assessment, and you'll have to sign a release form for the probation department to get the information from another chance on further with them. They'll provide that to them, and that should qualify you as long as you're still compliant at the time your case comes up. So, you'll need to see where people left, looks like. Yeah, okay. So you're gonna get your signed notes from mail. The hearing will be October the 6th at 11 a.m. So get your assignment notes from the bailiff, and you don't have to be here on the 23rd. Let's see, 22nd next week, right? You don't have to be here for that. And then see Mr. R.G. Mack in the hallway. He'll have you get an appointment to see Mr. Fulton for the three hearing. All right. Thank you. All right, Lacey Hildebrand.
Yeah, I'll get it in a second.
Okay, case.
1 second, please.
Case number 21 CR 70, State of Ohio versus Lacey K. Hildebrand. Present for the state, Prosecutor Attorney Collins, Assistant Prosecutor King. Present for the defendant, Attorney Danielle Witt. And are you Lacey K. Hildebrand?
Yes, sir.
All right. Let's see here. We just had an evaluation of Hildebrand, and I think this was a scheduling order. Yeah, this is the final pre-trial. We have a trial set for the 23rd of September. So where do we stand on this case?
Your Honor, if we could set a status conference for Friday even, so that Ms. Hildebrand has some more time to consider the offer.
Okay. Well, right now I should be here. I may have got a potential family issue. I might go out of town, but right now I think it's going to be all right. So let's set this for 11 a.m. Is that all right? Friday? All right. Friday, that will be February the 3rd at 11 a.m. So we'll see you back here then, State Prosecutor Attorney, and the bailiff will give you a sign. Friday the 3rd at 11 a.m.
Friday the 3rd at 11.
Thank you.
Thank you. Jeremy Menders. I did read this probation for qualification earlier, sorry about that. Okay. 21 or 20 CR 81. Case number 20 CR 81, State of Ohio versus Jeremy P. Bender. President of the state, Prosecutor Attorney Collins, Assistant Prosecutor King. President on behalf of the defendant, Attorney Dennis Kirk. And Mr. Bender is not present. I have a fax from the Probation Department which indicates that he has failed to report more pretrial supervision for your defendant. He was arraigned on the 13th and was told to report. Mr. Kirk, have you had any communication communication with you all?
I have not heard from him at all.
Alright. Okay, well, the court will order cases issued. And, we'll enact status until such time as he is brought back. Alright, thank you.
Thank you, Your Honor.
Obviously, right now, the other days are the 6th and the 25th of October, so we'll, do those on in case he gets carried out that long.
Even Ross County, back in Ross County, we won't get it forever again. If it was a year to find it,
Yeah, back in my day, it was Pike County. I can still remember Jim Beatty, who was the chief deputy, they never did arrest those people. It was one of the Warren boys, the older generation Warrens. And, they lived down on what was the name of that road? It was a road where it was lined with heathens, mostly Mormons and their associates. And so Beatty said, I know right where the hell he is. He said, I'm just going to get him. I said, we better call him back up. He said, oh, they won't send me in. He said, I'll be all right. So he went down there, he called him and told him. They said, you can't go down there by yourself. He said, we won't even go down there unless we have about 6 or 8 guys. But he said, well, I'm going down. So he went in there, and he went up there with about 10 of them there, he said, he just went up and said, you know, I think it was Dewey, but not Dewey. The hell was that? Anyway, he said, get your ass in my car. So he came up, surrendered, everybody stood there. He said, I have to hand him a gun, put cuffs on him, threw him in the car, and took him out of there. So, but I didn't know Ross County was going to be that bad.
Ross County won't serve papers for us or anything. They don't do anything.
Well, there's been a big change since, what's his name now? See, this is the color purple sheriff, isn't it?
Yeah,
Yeah, color
Well,
purple.
he's been sheriff for a while. I'll tell you that,
He's been there, I think, 2 terms, maybe 3.
it's been bad though for a long, I mean, when I was in juvenile court, I remember subpoenaing somebody from Ross County for a trial downstairs. And I called and said, like, you know, did you serve? Did you even try? No, but the trial's not till September 8th.
when we get this, okay.
Okay.
Yeah, this is someone at 3 o'clock.
Patty's-
So the same invitation.
Solar, Zoom.
Nothing used on the others.
Recording stopped.
Dallas. That's 13 Zooms today.
Yeah. Well, with all that's going on right now, the schools and COVID, I've decided to try to do as much as possible for Zoom going on. Till we see the breaks.
My mistake.
Is Greenville back in session?
14 Zooms. Yeah, they're back in session, but she canceled everything after school clear through Friday.
Including football?
Yeah.
I know they canceled Friday. Well, Leesburg is in the same situation.
The first 5 games they can win, and she's canceled 2 of them.
Well, Hillsborough, I know they said they had a whole bunch of people out. They have a lot of kids in quarantine.
Yeah,
I
Heather.
understand they canceled school last Friday. Because
Yeah.
they couldn't get enough staff. They get whole subs, they had too many.
Heather was over here earlier. She said that Davis was in the elementary and said they were thinking about canceling Friday and then go through all the fair week and then see what happened. But I tell you what, it's scary when you see 6,000 new cases a day in Ohio.
Well, this Delta, I mean, it's kicking ass. I mean, it's bad. And, you know, there's been some breakthrough infections. You know, generally speaking, the people that are vaccinated, if they do get it, they're not, you know, terribly ill, but, you know, still pretty bad.
Yep.
I just saw Kid Rock, had to cancel, tours that half of the band again had it, and he said they had been vaccinated. Again, don't know when. You know, you get vaccinated and still not already had it.
So Ryan Hughes used to be a deputy out
Yeah, he
died.
Yep. What's bad is all the kids.
Yeah.
You know,
Well, they're not sure if they're getting COVID or rhinovirus. And
well, in Leesburg, they said there was a large amount of rhinovirus plus some stomach. About half of them were like 80% out. No, maybe it was over 100, but anyway, half of them were COVID. That were either had COVID or were under quarantine.
well, the problem is those state indicators that the districts have to meet to get their brownie points has a 95% attendance for the year. You start having 2 or 3 days where you're at 87, 88, you can't overcome that.
Oh, I know. Yeah, I know. That's why they're doing it. Yeah.
I heard that Tim Detweiler got a personal call from Mike DeWine ripping him for shutting down. Said, we're trying to keep schools open and you do something stupid like that.
Well, it's happening all the same,
Recording in progress.
all right, put us on there.
All right. Radio.
Okay, can you hear me okay?
I can, Your Honor.
Okay. Case number 21CR115, State of Ohio versus Patty A. Sullivan. This hearing is being conducted by Zoom. You're Patty Sullivan there with Mr. Cordalis?
Yes, sir.
All right. And the prosecuting attorney, Annie Collins, is also appearing by Zoom. This Sullivan has been charged in 5 count act, 2 counts of theft, 3 counts of forgery. This is a first pretrial, and final jury trial is October 21. Trial date is November 8th. It looks like there's been discovery provided by the state back in July. Have you provided your discovery yet, Mr. Cordalis?
Your Honor, there is not at this time of defense.
Well, you'll have to file a compliance that just have nothing, then you file that because the court requires that. And if you do have any discovery, you do by the final pretrial. And do you anticipate any pretrial motions?
Not at this time, Your Honor.
Okay. Well, if you have any, those will be filed at a later final pretrial as well. And has there been a written plea offer received?
Your Honor, there have, sorry. I apologize.
You know, your client's were.
Your Honor, she is aware of it, and I had indicated to the prosecutor that my client would be accepting that offer, and we're going to be setting up the diversion interview and moving forward with having her screened for diversion.
All right, good. Well, as soon as you get that set up, and you would contact the court and get a time set up to do the plea and do that diversion agreement. All right, anything else?
Your Honor, I don't believe so.
Okay, all right, thank you.
Thank you.
Thank you, Your Honor.